Well, good evening, everyone, and welcome to tonight's webinar, Special Needs Trust. My name is Sandra Vanderveer Irwin, and I am the Director of Family Supports here at the St. Louis ARC. And we are so happy that you're joining us tonight for this very, very important topic. So, without further ado, I would like to introduce our very impressive panelists for tonight. We have Casey Stevens, who is the Director of Trust Services at Midwest Special Needs Trust. Michael Chiodini, who is a financial and investment advisor of his very own financial group. And last but not least, Joshua Hutkins, who is an attorney with Sandberg Phoenix. Welcome to all of you, and thank you so much for being here with us tonight.
Well, it's nice to meet or be here with everyone, and thank you for having me virtually. So tonight, this evening, you're going to hear from a panel of experts who are really going to go do an overview of special needs trust, special needs planning, public benefit eligibility, how to maintain it, how to qualify, and then really how to ensure that your loved one is financially secure long into the future. And so my presentation, my part of this is really going to be to focus on public benefits, what they are, how to qualify, what tests there are to qualify, and then how to maintain that eligibility. I'll provide a general summary of special needs trusts, and then I will end on some common pitfalls and common mistakes that we typically see with clients that turn into what we refer to as uh-oh moments, and then we'll also discuss, how we can resolve those. So when we talk about public benefits and public benefit eligibility, there are really two types of public benefits that we are looking into. And those would be public benefits that are not based on financial need, such as Social Security or SSDI, and Medicare. Now, when we talk about public benefits in terms of special needs trust, what we're really discussing is public benefits based on financial need. And the two main ones would be Supplemental Security Income, SSI, and Medicaid. And so when we are talking about special needs trust, what we're really doing is we're looking at how your loved one can receive an inheritance or some type of distribution while still receiving and maintaining that SSI and Medicaid eligibility. So we're really looking at how can we not disrupt public benefits. And so in order to fully understand how to not disrupt them, we first need to understand what they are. And the first main public benefit that we're going to talk about is that SSI, that Supplemental Security Income. So SSI is a federal program that is administered by the states, and it is state to state, so it's not the same for every state. And there are two main things that you have to prove in order to qualify. And that would be one, sufficient evidence of a disability, and then two, actual financial need. And when we talk about financial need, the question we get all the time is, well, whose financial need and what resources are we talking about? And so when your loved one is under the age of 18, we are not only talking about their financial need and their resources, but we are also talking about their mom and dad's resources. So it's really pretty unlikely that an individual will qualify for SSI based on financial need if they are under the age of 18, because everybody's resources are considered. Now, once that loved one turns the age of 18, well, then Social Security only looks at their financial need and their resources. And if they don't own anything at the time that they turn 18, well, then they will qualify based on that financial need. Now, if you've ever heard a presentation by one of my law partners, Bhavik Patel, he always refers to your loved one with a disability as Joey. And so to keep it consistent and make it a little bit easier to follow, I'm going to adopt that. And so when I refer to Joey, I'm really talking about, your son, daughter, loved one who has disability, who you're looking to qualify for public benefits for. So with that being said, SSI is only to be used to pay for Joey's food and shelter and nothing more. And so that's where you would have, a special needs trust to supplement what SSI does not pay for, because SSI is going to pay for that very limited food and shelter, and oftentimes it won't even cover all of their food and shelter. And so in order to qualify for SSI, we know that we have to prove disability and prove financial need. But in order to prove financial need, there are two tests that have to be that you have to pass. That is what's called the resource test and the income test. Now, an easy way of remembering, do I pass the resource test or the income test, is to think that you are on one side of a door. And on the other side of that door is SSI and public benefits. And so the first test, which is the resource test, unlocks the door. So in order to just right out of the gate, we know we have to unlock the door. So we have to pass the resource test. The income test is what's going to determine how wide that door is going to be open. And so if you're receiving, if you earn a little bit of income or no income, it's going to be open pretty wide. The more income you earn, the more that door becomes closed. But as long as you don't fail the resource test, it will always remain unlocked. Now, we know that we have to unlock the door in order to qualify for SSI, and we know that we have to pass the resource test, but what is a resource? We first have to understand what is counted as a resource of Joey. And a resource is anything that can be converted to cash for support. And so right off the bat, you should be thinking, well, if it's anything that can be included as a resource, does that really include, the clothes that Joey wears, Joey's phone, Joey has a computer? Well, all of those things are technically considered a resource because they can be converted to cash. They can be sold, and now Joey has, a resource. And what the resource test says is that if Joey's resources exceed $2,000 on the first day of the calendar month, then his public benefits will be lost until the resources are reduced, i.e. spent down. Now you'll see two numbers there. You'll see 2,000 and then just over $5,700 for Medicaid. Now it's possible you can qualify for Medicaid without qualifying for SSI because you're over the SSI limit. But what you should really take away from today, because SSI is such an important benefit, is that you really need to only focus on that $2,000 number. Because if you're under $2,000, you will qualify for both SSI and Medicaid. So assets that a beneficiary does not have the legal right to demand are not counted for SSI purposes. And what that's really talking about would be a special needs trust, which I'll get into a little bit more. But so as long as we stay under that $2,000 SSI limit, we will make sure that that door always remains unlocked. And that's really the goal. That's what we're trying to ensure, that no matter what, you, a loved one, a friend leaves to Joey, it never locks that door. So we always have to maintain Joey's assets under that $2,000 threshold. Now, I know I said that everything and anything that can be converted to cash is a resource, but SSI is kind enough to provide some exempt assets. And the first exempt asset that I'm going to talk about is a home. So SSI does provide that Joey can own a home as long as it serves as his principal residence. Now, I would caution you that it is not best practice to leave a home to Joey, because even though it's an exempt asset, there are other downfalls to it. If he owns the home and he receives Medicaid benefits, well, then Medicaid has the right to attach a lien to it. So that way, when Joey passes away or when Joey goes to sell the house, Medicaid's going to get paid back whatever they've paid for Joey's benefit. So while it does allow the door to remain unlocked because it's an exempt asset, it's not the best way to have Joey own that home. A better practice would be if you're going to leave a residence to Joey, that you leave it to him in a properly drafted special needs trust. He gets to have the benefit of it, but he himself doesn't own it, and so Medicaid would have no right to attach a lien to it. The other exempt asset would be household goods less than $2,000 of fair market value. Now, the good thing is you don't have to pay a lot of attention to it. SSI doesn't really pay a lot of attention to the household goods because it's very difficult to know who actually owns that iPad, right? There's no title to it. There's nothing that says Joey owns it. And so household goods is a little bit of a more of a gray area because a lot of those things don't have title. Another exempt asset would be a prepaid burial plot or burial space. And so let's say, for example, Joey ends up with some cash and you have to get rid of it in order to pass that resource test and keep the door unlocked. What you could do is you could convert that cash into a prepaid funeral plot. And because that's an exempt asset, the door remains unlocked. Another exempt asset is an automobile. So an automobile is completely excluded regardless of its value if it is necessary for Joey to basically get around, to get to work, to get to doctor's offices. And so what we're really talking about is one of those handicapped accessible vans, which can cost thousands and thousands of dollars. And so if for whatever reason Joey had to be the owner of it and that vehicle was necessary for him to perform his essential daily activities, that would be an exempt asset. Now, if it's not needed for those essential daily activities, well, then SSI limits it to a car that costs $4,500. So not only is it an inexpensive car, the thought is it's probably not a very safe car for Joey. And so we probably wouldn't even let him own that vehicle. Again, we're talking about special needs trust and special needs planning. That vehicle could be owned by his special needs trust, and he could still have the use and enjoyment of it. The other exempt assets, as you see here, it'd be life insurance, an ABLE account, and then assets in a properly drafted special needs trust. So life insurance is exempt so long as the face value is less than $1,500. So you're not gonna have a large whole life policy, but you could have term life insurance. So Joey could be the owner of a term life insurance policy. And then you have the ABLE account, and all assets in an ABLE account, so long as the maximum value at any given time is under $100,000, that is an exempt asset and will not be counted against him for SSI purposes. So it would keep the door unlocked. So if Joey had a job and he was working and his assets were accumulating, that is where you could put that money into the ABLE account. Now you are limited on how much money you can put into an ABLE account each year. And that current number for 2024 is $18,000. And so you could put $18,000 into an ABLE account. It would keep the door unlocked. And as long as the total value of the ABLE account does not exceed $100,000, it is an exempt asset. Now, again, I wouldn't recommend that you just run out, open an ABLE account and start putting money into it. While it is a very useful tool, there are drawbacks to it. For example, there's also a Medicaid payback provision to it. So Medicaid has the right and the ability to basically take back whatever they have paid during Joey's lifetime. So if Joey passes away and money remains in that ABLE account, Medicaid's going to be the first beneficiary of that account. And really, so because of that payback provision, I would never recommend a parent or a guardian putting money into Joey's ABLE account. It's really there to where if he receives a gift, or again, he's earning money, it's a place that he can put his own money into and then prevent that door from being locked. And so again, I would never put a third person's money into it. It should only be the disabled individual's money going into it. And then the last exempt asset would be those assets in a properly drafted special needs trust. The benefit of that special needs trust is really that anybody can leave money into it. There's no limit in terms of how much money can be left in it. So, if he were to receive an inheritance of $2 million into that special needs trust, that $2 million will not count against his public benefit eligibility. It is always an exempt asset. And then the purpose of a special needs trust is really a way to provide private funds to Joey in order to maximize his public benefits. So it is there to supplement what he's receiving from SSI. And then a well-structured special needs trust can provide really financial security for Joey's lifetime. Now, when we talk about special needs trusts, we like to break it down in two pretty broad categories. The first one we would call more of a reactive trust, meaning Joey received some type of money and the door is going to be locked. And so we're scrambling around trying to figure out, what can we do to make sure that the door isn't locked, that he maintains eligibility. And so what we're looking at is what's called, it has many different names, but most typical, it would be a Medicaid payback trust. You may also hear it called a first party trust, a self-settled special needs trust, or a D4A trust. And really what that's there for is we call them uh-oh moments, right? Joey received a gift, he received an inheritance, we have to do something with it. Well, we put it into this Medicaid payback trust and keeps the door unlocked. It's there to be used for his lifetime, for his benefit, but just similar to the ABLE account, it does have that Medicaid payback provision associated with it. So whatever's left in that bucket when Joey passes away, Medicaid is going to be the first in line to receive the benefit. So again, it is more of a reactive type of trust. It allows him to qualify for public benefits, but it's not in our opinion, it's not the best route to take. It's better to be proactive. By being proactive, meaning parents, guardians, they are proactive. They make sure that whatever they leave to their Joey, to their child, never disrupts their public benefits. And so when talking about proactive planning, we're talking about a third-party special needs trust. By third party, I mean it's not Joey's money going into it, because with the first party, Joey received that inheritance or he received that gift, so now he owns it and then he transfers it out. Whereas the third party, it never becomes Joey's money. It's mom and dad's money, grandparents' money, friends' money, whoever it is. And then they transfer that into that third party special needs trust. And so somebody else is funding it. That third party special needs trust is always exempt from the resource test, and there is no payback provision to it. And so when we're dealing with third party special needs trusts, there are two main types. And you would have what's called a standalone special needs trust, or what we refer to as a testamentary special needs trust. The standalone trust is a document, is a trust that is created today. As soon as you sign it, that trust is in existence, and anybody can fund it at any time. So if you were going to talk to grandparents or friends, and you found out that they were going to leave Joey a distribution under their estate plan or under their retirement account or whatever however they're going to leave money to them, you would do that standalone special needs trust because it exists today. The other type, that testamentary special needs trust, is basically it's laying dormant and it doesn't exist until mom and dad both pass away. And so it can't be funded until that time. But what it does do is it says that when mom and dad pass away, that trust springs to life. Whatever they were going to leave to Joey funnels into that bucket, and whatever Joey receives in that is exempt. He can use it to supplement public benefits, and it just makes sure that that inheritance never disrupts his eligibility. All right, so some of the major pitfalls that we see, and then I'm going to go over them and then talk about how special needs trusts can help prevent these pitfalls from happening. The first one is a Transfers to Minors Act account, so a custodial account. And this is basically where somebody leaves Joey money, but on, let's say on the check, they write, to mom and dad for Joey as custodian. And so that goes into this Uniform Transfers to Minors account. And while the biggest problem is while mom and dad have control of it to use for Joey's benefit, it's not an exempt asset. It was not on that list of exempt assets. And so if it accumulates over that $2,000 limit, it will disqualify Joey from public benefits and it will lock the door. And so if he has it when he's under the age of 18, it's okay, because again, prior to 18, we're looking at mom and dad's resources plus Joey's resources. But once he turns 18, if he still has this Uniform Transfers to Minor account, he will not qualify, and that door will remain locked. And so it's really not, it's not the best type of account to have if the goal is to qualify for public benefits. And so special needs trust comes in because instead of a friend leaving the money to mom and dad as custodian for Joey, they can leave it to a special needs trust for his benefit. That trust can hold money from anybody. It's a third-party special needs trust, and mom and dad can be in charge of it, and it's always an exempt asset. So what you could do, if you could, what I would do is I would ask anybody, hey, do you plan on leaving something to Joey? If so, don't leave it this way, write it out to the special needs trust. And then the next one is unstructured beneficiary designations. And what we're really talking about here, it would be IRAs, 401ks, life insurance. And so, a lot of employers, when you get a new job, you have all these benefit forms that you fill out. And chances are you put your spouse, if you're married, as the primary beneficiary. And then you would put, your children, Joey, Emily, as contingent beneficiaries or secondary beneficiaries. So they would receive it upon the death of your spouse. And while the distribution to your spouse and to Emily would not have any impact on public benefits, well, if Joey is listed individually as the beneficiary on life insurance, IRAs, 401ks, well, that distribution is guaranteed to disqualify him from public benefits and lock that door. And so the recommendation would be get a change of beneficiary form. Wherever you see Joey's name, swap it out for Joey's special needs trust or whatever the name of that trust is, which would then guarantee that whatever he receives as a beneficiary of those policies, it goes into the special needs trust, it's exempt, and it won't disqualify him from public benefits, and that door remains unlocked. And then the next one is directing funds to be held informally by another family member. And what we're essentially saying is you are choosing to disinherit Joey as a beneficiary of your estate. So really the individual who may need the money more than anybody else, you're taking the approach of, I'm going to leave it to somebody else, his sister Emily, and nothing to Joey. The thought being that Emily is going to be there to make sure that Joey's provided for. She's going to use the money for Joey's benefit, and she's just going to do the right thing. And there's really, I'm not going to say Emily's not going to do the right thing, but Emily could be going through certain things in her life that would impact her ability to provide that money to Joey. So for example, if Emily is going through a divorce and you've left all the money to her, well, now there's a pretty good chance that half of that inheritance that's supposed to be used for Joey's benefit, because he needs it the most, is going to be going over to soon-to-be ex-spouse. If Emily is in a car accident, she's being sued, or really whatever's going on during her life, you've just caused that inheritance that was for Joey's benefit to be subject to her liabilities. So while you may have had the best intention of, I'm going to leave it to Emily, it's not going to, exclude or it's not going to prevent him from receiving public benefits, it's possible that that money's going to go have unintended consequences and go somewhere else. The next pitfall that we see would be gifts from non-parents. So I've mentioned, a little bit ago about grandparents, aunts, uncles, friends, or other family members who would want to leave Joey a distribution because they know how much he needs it for his financial security. Well, if they put Joey in their estate plan, or if they write him a large, birthday gift check, well, those funds are going to disqualify him from receiving public benefits. And so it would be, it might be advantageous it might help make that conversation happen by just saying, hey, I don't know if you were ever going to leave Joey any money, but it may, if you were, I would appreciate if you left it to him in a special needs trust. You can give him the name and all the information for it, and then they can just write it there. Anybody can leave him anything, and it won't disqualify him from benefits. It's also a nice way of maybe they weren't even thinking about it, but now that you brought it up, they might add Joey to their estate plan. And then the last common pitfall that we see is, family members, mom and dad, just don't do any planning at all. And when you don't do any planning at all, every state has its own estate plan built for you. So for example, the state of Missouri says that if you pass away and you do not have any estate documents in place, then, and you're married, half of your assets, roughly half of your assets, go to your surviving spouse, and the other half goes equally to your children. And so the unintended consequence is not only does your surviving spouse not receive it all, but whatever is going to go to Joey would disqualify him right away. And then we're back in that reactive measure of this, where does the money go? What do we do with it? And then if you have children and you're not married, Missouri says all of it goes into, goes equally to however many children you have. And so really by not doing any planning, you have set it up worse than before. And I'm not saying that like you have to create the most bells and whistles estate plan, but if you do have a disabled child, you almost have an obligation to make sure that whatever they're going to receive does not prevent them from qualifying for public benefits. And so you at least have to do the bare minimum and create some type of vessel that won't that will be an exempt asset for Joey's lifetime. I'll sort of leave it at that. And then if there's any questions, I'm happy to answer any questions. How much does the cost to set up a special needs trust? It's a wide range. I would probably say it's anywhere from $1,500 to $3,000, but it really depends on what type of trust we're setting up. How do you leave a home to a special needs child so it does not affect their SSI? And so really, I mean, the recommendation would be to leave that house to them in a special needs trust. So the special needs trust can own the home, and Joey can live in it, can reside in it, and it wouldn't impact their SSI. Now, because a home is an exempt asset for SSI, we're really talking about more worried about Medicaid having that payback prohibition to it. But you can own the home while you're living and then do what's called a beneficiary deed, which transfers ownership of the home to mom and dad, or to Joey's special needs trust upon mom and dad's passing. And then, is it best to leave property in a special needs trust for our children, or should we leave it to the trustee who can then rent it? So you can leave it to the special needs trust, and the trustee can still charge Joey rent. And so I understand what you're trying to do is basically maximize how much SSI they are receiving. So I would recommend leaving it to the trust, and then if you're looking to do rent, just have the trustee of the trust charge the rent. We have a special needs trust in a different state. What happens to it now that we live in Missouri? So chances are that special needs trust is going to be valid in every state. There's what's called this full faith and credit clause. It's valid in one state, it's going to be valid in Missouri. If you had concerns about it, we could always look at it, and there are ways you can update it to reflect the current state's laws, but chances are it's going to be valid everywhere. So Medicaid can take money left from a special needs trust after a loved one dies. After special needs. Okay. So in case it's probably going to touch on this a little bit more, but it depends on what type of special needs trust. If it's a third party, the answer is no.
Yeah.
If it's a first party, the answer is yes.
Right.
So it's the proactive trust, that proactive third party trust, that does not have the Medicaid payback provision. The first party, more reactive trust would have that payback provision. And then this next one, with a plain vanilla trust already set up, absent a special needs trust, what should you do? And so really, I mean, it sounds, if a family trust is already set up, you need to do an amendment or maybe a complete restatement of it to then include special needs provisions into it. Because I'm assuming the way that it's set up now, it just says when mom and dad pass away, it just goes to the kids in some form or fashion. And if it doesn't have specific special needs trust language, it's gonna cause disruption and disqualification.